Good afternoon, everyone. Thank you so much for joining and welcome to Empower Together, Navigating Legal Changes in Response to COVID-19. This webinar is presented by LevittQuinn Family Law Center and the Reape-Rickett Law Firm. My name is Sarah, and Anastasia and I will be assisting in today's webinar. So today's speakers joining us is going to be Mr. Matthew Breddan, and he's the shareholder at the Reape-Rickett Law Firm, and he's been practicing law for over 25 years and also serves as a temporary judge and mediator. In addition to his legal service, Matthew Breddan is a board member for a nonprofit domestic violence shelter. Ms. Diane Sandoval is a staff attorney. Ms. Sandoval works to connect legal information and access to underserved communities. So today's topics, the impact of COVID-19 on family law services. Mr. Breddan and Ms. Sandoval will be addressing the current court closures and limitations for both Los Angeles and Ventura counties, as well as the process. Additionally, they will provide information for domestic violence resources and clarify the limitations and services provided by the court's self-help and mediation services. Finally, Ms. Sandoval and Mr. Breddan will address questions submitted by our audience to help you navigate the current situation. We encourage you to submit your questions during the presentation, and we'll address as many as possible, time permitting. To get us started, Mr. Breddan will share information on the status of the court and how it impacts you.
Thank you, Sarah. Good afternoon, everyone. Thank you for joining us. Right now, the information we're giving you is subject to change. Everything is very fluid. Both LA and Ventura counties are closed at least through May 12th, but the word on the street is that it will be continued at least until mid to late June. The difference is that each court system is hearing different matters. In Ventura, they are only hearing emergency ex parte applications and applications for temporary restraining orders. In LA County, they're hearing that as well as matters involving child abduction cases and Hague Convention proceedings. So as of now, the courts are scheduled to be closed through May 12th, but we're anticipating that it will be continued out at least another month.
Good afternoon, everybody. I want to talk to you guys a little bit about the family law filing situation in both Los Angeles County and Ventura County. Now, in Los Angeles County, while the court is closed, you can still file requests for orders, judgments, divorce petitions, paternity responses, and so on. You can do so through mail filing, fax filing, or a physical drop box. Now, these drop boxes can be found at all of the courthouses in Los Angeles County that service family law, like Pomona, Van Nuys, things like that. An example of this is one of the drop boxes can be found at the Stanley Moss Central Courthouse on Grand. Now, if you have a filing that requires a payment, there are credit card slips available at all of these drop boxes. Moreover, if you previously submitted a stipulation, a judgment, an order after hearing, something like that, before all of this went into effect, all of these things are still being processed in Los Angeles County. It's slowly, since the court is not currently staffed at full capacity. Now, while Los Angeles Court continues to accept new filings at this time, the priority of matters is something to keep in mind. When the court resumes normal functions eventually, it will likely prioritize matters. Based on information we've received from the Los Angeles Superior Court judges, restraining orders would be the things that would be given first priority. After that, it would be initial requests for custody, support, and fees, followed by modifications of any of the above custody, support, and fees. Lastly, it would be everything else. Deciding whether or not you should find an alternate path, and that's something that we'll discuss in a later slide. Now, Ventura County is a little bit different in that it's not accepting any new filings at this time, except restraining orders and ex partes. If you're filing a restraining order or an ex parte, it can be done via email, or it can be done in person at a drop box found at the Hall of Justice. Now, any non-emergency filings will be rejected in Ventura County. But let's say you need to file a modification of support and you're not allowed to file it in Ventura. Because of the Supreme Court's Rule 13, you can actually mail you can mail or serve it on the other side, and it can be retroactive to the date that you mailed or served it, even if you're not able to file it.
I'm going to briefly touch on the issue of ex parte applications. As a general proposition, ex parte relief is only appropriate in matters of irremediable harm or imminent danger. And that's typically when you're dealing with matters involving the children. So child abuse, child abduction, things of that nature. We have attached a slide down below that will list it for LA County, all of the email addresses that you can use to file your ex parte applications. Both courts will decide the matters on the papers. Both, when I say both courts, I mean LA County and Ventura County. They will decide the matter on the papers unless, of course, the judge decides that the hearing is necessary. In LA County, you have a little more latitude in how you can file them. It's either via email, physical Dropbox at the courthouse, or in person, whereas Ventura just has email or Dropbox at the Hall of Justice. And again, they both offer either in-person or telephonic type hearings. In LA County, it's court call, or if you're in Stanley Mosque, it's by using a system called WebEx. And in Ventura County, it's an actual conference call, not court call or any formal mechanism like that.
Because both of the courts are closed for so many types of matters right now, we wanted to let you guys know other ways that you could potentially resolve your issues. If there's a chance of you resolving all or part of your issues, mediation could be an option. While the Family Court Services mediation offices are currently closed in both, received note today, or word today, that the court is implementing a new online tool to use as a negotiation tool. It's called the online dispute resolution. It's a negotiation tool that can potentially allow parties to generate a parenting plan agreement, able to reach an agreement. Now, the way that this works or will work is one party signs up for the program, and then the other party will receive an email regarding their participation. Once both parties participate, then the negotiations can begin and hopefully an agreement can be generated. Now, in addition to the online, there are other mediation offices. There are private attorneys who do mediation. There are many companies who do mediation, and there are private judges who also work as mediators. Now, if you're interested in mediation services, we will have a slide down below with some information on companies and different legal organizations that do in mediation services, or bar associations, that would refer out to attorneys earlier. And the idea that priority is going to be given to certain matters. A good example of when mediation could be helpful and productive is when a dispute is about money or property. These types of cases will be heard last when the court resumes its normal functions. And as this is the case, it would make mediation worth considering because it could be a very long time before you're heard. Now, it can be helpful for some cases. It's not necessarily recommended for those experiencing domestic violence or those with restraining orders. You don't want to open yourself up to situations where you might feel unsafe in an effort to avoid court.
Speaking of restraining orders, if you feel that there is an immediate threat, call 911 immediately. When the law enforcement officer arrives, you can ask for an emergency protective order. That will basically buy you some time to get into court and file a request for a temporary restraining order. You do not need to have an emergency protective order to get a temporary restraining order, but it will help protect you in the short term, or it will provide you some protection. There's a lot of resources in LA County. There's a self-help center that is being staffed, and the phone number is listed with the hours. And in Ventura County, they also have a self-help center, but they're currently closed. So we've listed an email address where you can download the forms and start the process. The emergency protective order is typically issued for a very brief period of time to allow you to get into court and file for a restraining order. But given the current situation with the virus, it has been extended for an even longer period of time. A temporary restraining order under normal circumstances is valid for 21 to 25 days by statute, but that has also been extended for up to 90 days. Once you've been granted a temporary restraining order, there will be a hearing set at the end of that 21 to 25 day period or 90-day period as it is now. And you'll have a hearing where you can present all your evidence, your witnesses, elicit any testimony you may have. And then the court, if you've met your burden of proof, the court will then grant you the restraining orders for a period of up to 5 years.
Just a few more important points when it comes to restraining orders during this time. In Los Angeles County, the Sheriff's Department is still serving restraining orders. When you are filing a restraining order in Los Angeles County, you can file electronically or in person, but please do not place your restraining order request inside the drop box. Let the officer at the bailiff at the door of the court know that you're filing a restraining order, and they will direct you to the appropriate place to file. It's important to note that even if you have a hearing set, it doesn't necessarily mean that you're going to be heard on that day. If you have a hearing, the only hearings that are going forward during this time is if you guys or the parties cannot reach an agreement or the judge requires the hearing to go forward. Now, if you have a hearing, there's a few different ways that you can appear. You court WebEx, which I believe is only being used in 2 departments at the Central Courthouse right now, Department 18 and 22, or you can appear in person. Now, if you're appearing in person, you should adhere to the social distancing regulations, and you should also have your case number ready when entering the court because you will be asked for it. Now, lastly, in Los Angeles County, if you have an emotional support person from a DV Alliance group, that person is still allowed to go into the court with you. While there are very limited people who can enter the courthouse right now, emotional support people are still being allowed in at this time. Ventura County, we have some of the information for filing a restraining order here. Again, it can be done via email at this address, or it can be done in person at the Hall of Justice. Please make sure to get your restraining order request in by 1 p.m. if you want orders on that day. Additionally, temporary restraining orders in Ventura County are being granted on the paperwork alone unless the court determines that an appearance is necessary.
And this next slide lists a lot of domestic violence resources. All of the shelters and the legal support entities and law enforcement entities that we've listed here they're currently open and taking new applicants and offering assistance. It's important to note that each one of these entities has different requirements and different thresholds. So make sure that you are as precise as you can be in the help that you need and in answering the questions that they ask you in the most accurate and precise manner possible. That will determine what services are available to you and from which of these entities and companies. So there, again, we put this on previous slides, if there is a life-threatening emergency, call 911. Don't bother dealing with any of the other phone numbers right away. The most important thing is that you maintain safety and you and or your children are in a safe environment.
Great. Thank you, Nalleli, and thank you, Matt. This wraps up the presentation portion for today's webinar. Mr. Breddan and Ms. Sandoval will now be addressing questions submitted by our audience. So please feel free to submit questions via the Q&A feature, and we will do our best to answer as many as possible, time permitting. Again, please don't submit any case-specific questions or include any personal details, as we aren't able to address those in a public setting. Additionally, we'll be focusing on addressing questions directly related to today's topic. So while we give you the opportunity to gather your questions, we're going to start with some of the questions that were submitted with the registration.
So the first question we received was regarding what do you do if the other party is violating a domestic violence restraining order? And the bottom line is the answer to this question boils down to how severe the violation is. If somebody's pounding on your door and threatening immediate harm, you call 911. If somebody sends a text message saying, I love you, and you may not want to call 911 for that. You may want to wait until the court's open and compile that. But you have to be aware of your safety. And if you think that things are escalating to the point or can escalate to the point, then always avail yourself to 911.
All right, question number 2 states, if I'm protected by a domestic violence restraining order, do I have to wait for the orders to expire or be dismissed to file a divorce? Now, the law allows a person to file a divorce or a paternity, anything like that, before a domestic violence restraining order has been expired or it dismisses. What will happen eventually is that the restraining order will then go under the bigger picture action.
The next question is regarding a post-judgment issue following we're assuming a judgment being entered, and the person asking the question lives out of state. The easiest and best way to file is to get local counsel, just because they're familiar with the rules and the procedures. But if you don't want to, you can send it to the court via email, or via FedEx or overnight mail, or any of the other means. Again, if we're still living in this COVID environment, any of the other means that we have set forth previously. If it's in LA County, if it's in Ventura County, they're not going to hear anything right now, and they're not going to accept any filings right now. So it's best to hold on to that issue until such time as the courts reopen if it's a Ventura case.
And I do want to quickly mention that we did get some questions regarding custody and visitation, and I understand that that is on people's mind a lot during this time. And so while we can't particularly answer any questions regarding custody and visitation at this time, we will in the future be offering another webinar where we only focus on custody. You know, check on your email and see when that will be coming to you.
So we've also been asked a question on how to, what is the process to file an ex parte? So that hasn't changed. Before the lockdown and the court's closure, in order to have the court hear an ex parte, you had to give notice to the other side before 10 a.m. the day before, and then they could show up or not show up as they deemed appropriate or fit, and then you would submit your paperwork to the court the day of. I'm not aware of any changes in that. Nellie, are you aware of any changes in that process?
No.
So
the notice requirements stay the same, just the accepting file.
Correct. So you would have to give notice to the other side. That could be done typically by telephone or email, or we don't recommend text message, even though I've seen some courts accept that. And then you just submit your paperwork according to the procedures that we've already outlined.
All right, and we have another question here. How do you use court call if you have an upcoming hearing? I would reach out to the court clerk, and I believe that they guide you. I'm not particular on the actual uses of court call. Mr. Breddan, you might have a better idea of how to communicate with the court using court call. I do know that the price has been lowered during this time, and I know that you should reach out to the court clerk, but other than that, I'll let Mr. Breddan take it away.
That's actually very good advice. You call the court clerk, first of all, and tell them you'd like to appear by court call. They will give you their name, and they will give you permission to appear by court call. Then you'll go to courtcall.com, or you'll call their phone number, which is listed on the website, and you'll give them the case number, your name, and whether you're self-represented or you've got counsel involved. And then they'll just set it up for you and send you an email with confirming information and the court call codes that you have to put in to get access to that particular court. It's advisable that you get that done as soon as possible prior to the hearing, so there's enough time for everything to work through without any bugs.
And there is one more note about calling your court clerk. Now, because most of the departments in the family law division are closed, there's only 4 open departments. I know that the Los Angeles court website has the department that is currently taking over all of the others. Let's say if Department 2 is taking care of what would normally be 13, 84, and so on. And so those are actually listed specifically on the court website. But if you're trying to communicate with a clerk, make sure that it falls in line with the courtroom that you're actually going to be appearing at.
We got another live question that asked if we think a 217 hearing scheduled for mid-June in Stanley Mosque will go forward. The best answer I can give is, I don't know. I doubt it. I think it would depend on the issues. There has been a lot of talk that once the courts do open up, a lot of the judicial resources will be dedicated primarily to criminal matters, or else the criminal defendants the criminal complaints will have to be dismissed. All of that is yet to be seen. I don't even know that the courts are going to be open by mid-June. Again, the word on the street is that the current dates of May 12th are going to be continued out, and it's going to be at least another month. So it's just one of those things where you're going to have to play it by ear and keep an eye on your email or your snail mail to see if you get the notice of continuance. And we got another question. Nellie, do you want that, or do you want me to answer that one?
I don't believe I see that question.
Okay, so the next question was, do I have any insight on Zoom depositions where documents have been requested from the deponent? This has been a very hotly debated topic amongst a lot of our colleagues as to whether or not you should even conduct a deposition by Zoom because of the ability for the process to be abused. Some people think it's fine. Others are having trepidations about it. If you have documents that need to be produced, I don't know how you would get them unless they were FedEx to you, and then you'd have to have a separate copy to send to the deponent who's going to be questioned on them. So there are logistic problems, but nothing that can't be done if you really want to have the deposition go forward. I don't know that there's any judicial intervention on that. I think it's just a matter of your preference and comfort zone. And we got something else just popped up. Hang on one second, please. The next question was regarding a domestic violence restraining order. Nellie, did you see that one?
Violence restraining order also protect my parents and children. That would depend on whether you requested that they be included as protected parties. It's not something that automatically happens. It's something that you do need to request when filing your request for a domestic violence restraining order.
Are there any other questions?
We are.
Two more.
All right. Matthew, would you like to take the first one?
Sure. The first question is, what has your experience been with ex partes downtown regarding child custody? Again, that's a very difficult question to answer because the world is very different now under the COVID parameters than it was beforehand, and each case has different nuances. So if there was a case where, let's take, for example, a child was being severely beaten or abused, you're going to get the relief you're requesting. If it was a matter that little Johnny doesn't want to go see mom, the courts are probably not going to construe that in a vacuum as being subject to an ex parte. Again, if you consider that an ex parte, you're asking the court to basically jump you to the front of the line from all the people that have filed their paperwork and waited for their hearing, you have to have a really good reason why the court should hear your case out of order. And that's typically when there is a true dire emergency situation. So that should be the underlying theme for any ex parte you're contemplating.
All right. And so we have another question here. I believe it says, I have an LA court hearing tomorrow at 8:30. If the court is closed, what will happen? Now, I don't know what type of hearing this person has. If it's a domestic violence restraining order hearing, then more than likely you should appear, whether through court call, WebEx, or in person, and then you can be given a continuation date there. Or, you know, if it's one of those cases that the judge is going to require a hearing on, then it would go forward. If it's a hearing on another type of case or another type of matter, you should have more than a continuation date. You can always call the court clerk, your court clerk, if you have any questions regarding any other types of hearings.
Then we got another question regarding a restraining order and whether it stays in place even if the restrained party files a motion with the court. And the answer is the restraining order will stay in place until it expires or until the court modifies the orders. All court orders remain in effect until they're modified or by stipulation or by court order, or they terminate as a matter of law. So if the restraining order was set for 6 months and the restrained party files a request for orders in 9 months, then you don't have a restraining order at that point unless it's been renewed. So I think that's the last question we have time for in this afternoon session. We hope that you found this beneficial. I want to thank Nellie and the other panelists for helping out with everything. And I think you'll be getting a questionnaire at the end of the presentation.
Yeah, thank you guys so much.
Thank you all so much for joining, and thank you, Matt and Nalleli. We just sent out a poll, so we'd greatly appreciate if you could take a look at that and let us know what was the most beneficial for you. And that does wrap up our first webinar. We hope that the information was empowering and this will help you navigate the family law services during the health crisis. We apologize if we were unable to answer your question during the webinar. If there were any re-registered ones that we weren't able to get to, we will try and follow up with you. Additionally, webinar discussing issues of custody, support, and the implication of the CARES Act and more. So be sure to tune in to our upcoming events. We'll be publicizing that via email and social media. And if you do have any case-specific questions or concerns that you would like addressed, feel free to contact LevittQuinn Family Law Center or the Reape-Rickett Law Firm. Our contact information is available here on the last slide.